Justice Ginsburg and I met over opera. It was almost 25 years ago, and I was a law clerk on the U.S. Court of Appeals, and she was a judge. And I would see her coming down from exercising, and we would sometimes meet in the elevator. And I couldn't think of what to say to this incredibly intimidating and impressive woman, so I just started chatting about the one thing that I really love, and that is opera. And it turned out that she liked it a whole lot too. And we very quickly built up a friendship over the years, bonding over opera and talking about it in all of its dimensions. And I could never have imagined when we first met that it would all culminate in this spectacular performance this evening. So, assuming that the mic is working well, ladies and gentlemen, I just can't tell you how honored I am to introduce to you the great Justice Ruth Bader Ginsburg.
Which side do you want me on? Can I go here?
I had no idea it was so good.
Oh, you didn't hear my greatest aria. It's about those who know a little bit about the Magic Flute. The next opera, the Washington National Opera, is the Magic Flute. And there is a major role for the Queen of the Night. So in one of the scenes that was left out, I break through the glass ceiling to rescue Justice Scalia.
How do you rescue him?
By doing a lot of singing, till I think we wear the commentator's patience then.
And isn't there some conceit that you're trapped on a desert island and the only way you can escape is by agreeing on a common constitutional methodology?
No, we agreed to be different.
You agree to be different. Well, you know, that I have to tell you, that line at the end, "We are different, we are one," first of all, is incredibly moving. And really, it's what the National Constitution Center is trying to embody, this idea that in this country, so riven by partisanship and polarization, people can still strongly disagree about the Constitution, but still be united by the Constitution. Is that a realistic hope?
I think it is. It was for me, and it was for Justice Scalia. When he was nominated, although his views were very well known, he was confirmed unanimously. And I came pretty close to that. The vote on me was 96-3. It would not be that way today, but don't you think that's the direction in which we should seek to return?
Yeah, yes. Enthusiastically, everyone says yes. How can we seek to return there? What can we do? What can the National Constitution Center do? How can we explain the fact that you do have this friendship, and although you can disagree constitutionally, you are united by love for the Constitution?
But I think that, and as Derek Wang captured it so well, we do revere the Constitution and the institution of the court.
Everyone wants to know, of course, whenever you go out, I'm sure you're asked this, how can you be friends given the fact that you disagree?
We were colleagues on the Court of Appeals, and one thing about Justice Scalia, he is a very funny man. You know, every year they rate us on how many laughs we produce an argument, and Scalia is always number 1, and I am always number 9. But sometimes he could say things, and I had to pinch myself to stop laughing.
And you also share this love of opera, and you spend New Year's together?
Yes.
What did he think of the opera? Oh, I'm so sorry he's not here, but what did he think of Derek?
But he liked, I think when Derek first came to him and said, "Do you mind if I do this?" And his answer was, "You have the First Amendment right to do this."
And after seeing it?
I think he enjoyed it very, very much, and particularly the tribute to his father and in the aria
Yeah.
about building stairs.
So, okay, we have to do a little Name That Tune because I know we were both picking it out. I heard some Puccini in the Name That Stairs and some Handel in Justice Scalia's first
Yes,
aria.
yes. This is, the Rage aria is definitely Handelian.
And you started as Carmen, and then I heard you some Mozart, some Così fan
Yes.
tutti, and what else? And Dido and Aeneas was in there too. What else did you?
And where is Derek? He should help out and tell us.
Who
Tell us
else
what-
was Justice Ginsburg's music derived from?
Begin with she's a reasonably evolving constitution, so her music evolves over the course of the aria. We begin with Carmen, and we go into a melody that's reminiscent of the Verdi style, which then goes into a jazz waltz style, which then ends somewhere in the Whitney Houston, Aretha Franklin. The second aria is Mozartian. It's a symphonic sonata movement with concerto elements and a few.
It's just spectacular. We said over cocktails, you're going to be, first of all, this was your line, the court composer, and we want you to set each of the amendments to music as well.
And you should appreciate that every line in the libretto is footnoted
Wow, wow.
with references to opinions, to articles. So it's staggering the job that he did.
It is staggering, and you wrote all the lyrics too, which Ira Gershwin would have been proud, or W.S. Gilbert. What are some of your favorite lines? I know you know some of the couplets, but
Well, I like the one about the Constitution, but like our society, it can evolve.
it's magnificent, and I never knew that anyone could find a rhyme for Craig v. Boren before. That was very well done.
And what a lot of those references may be hard to grasp. That's why the footnoted version of the libretto should be published.
And
Those were all cases that came before the court in the 1970s.
well, speaking of those cases, your aria was indeed a collection of the cases that you won as an advocate before the court in the 70s that made you, as many have said, the Thurgood Marshall of the women's movement and more responsible for the rise of gender equality than anyone else in this country. You recently honored the Constitution Center by sending us a spectacular gift, and that is a signed copy of your brief in the Reed versus Reed case. Tell us about that case and why it was so important to you.
Rights were alive across the land in the 60s as a result of the civil rights movement, but the United States Supreme Court had never, in its entire history, held any classification based on gender unconstitutional. Derek's lyrics include a case called Gossett against Cleary. It was typical of the way things were. This was a woman who owned a tavern, and her daughter worked as her bartender. The state of Michigan passed a law that said a woman can be a bartender only if her husband or her father owns the establishment. So that law immediately put the Gossett's mother and daughter out of business. The Supreme Court didn't understand. It viewed this law as protecting women from the evils of barrooms. Of course, they never noticed that the people who were bringing drinks to the table and were not separated from the customer by a bar, they were women. But the irony of the Supreme Court view that Michigan law helped women, it protected them. That's what had to be dislodged. The court was of the view that differential treatment of men and women by the law operated benignly in women's favor. So many people were looking for the perfect case to disabuse the court of that notion. And Sally Reed's case was that case. Sally Reed was a woman in Boise, Idaho. She had a son. She and her then husband separated when the child was, the legal expression is of a tender years. When the boy reached his teens, the father applied for custody. His argument to the family court judge was, now he needs to be prepared for a man's world. Well, Sally Reed didn't think much of her, by now, ex-husband, and urged the judge not to give him custody. She was unsuccessful, but she was right in predicting that the father's home would not be good for the boy. He got into trouble and he spent a year in a youth detention center. Sally again asked if she could be the custodian. The boy was again returned to his father. And one day he took out one of his father's many guns and committed suicide. Well, Sally wanted to be appointed administrator of his estate. And she filed her application with the probate court. Not because there was any economic gain for her, for sentimental reasons. The father applied for custody, to be designated administrator of the estate about a couple of weeks later. And the probate court judge had a hearing, and he explained to Sally, this is the law of Idaho. It says, as between persons equally entitled to administer a decedent's estate, males must be preferred to females. Now, it was very hard to see how such a law could be perceived as operating benignly in women's favor. So Sally Reed's case came to the court, and she won unanimously. And for the first time in its history, the Supreme Court in 1971 held a law unconstitutional because it discriminated arbitrarily against women. One of the beautiful things about that case is Sally Reed was an everyday woman. She financed the case on her own dime all through the Idaho courts. She believed that we had a justice system that would vindicate her right to be treated equally. And that there are people all over the country, in the civil rights movement of the 60s, in the revived feminist movement in the 70s, who trusted our system to be able to right an injustice.
We're so honored to have it. We're going to put it in the permanent exhibit right next to the description of your achievements for gender equality. And I want you now to tell me what is the rest of the story. Your strategy was to move incrementally, to represent men often who were being favored on the grounds that the male judges would sympathize with that. And how did you take the case up from Reed v. Reed to the Virginia Military Institute case, where you persuaded your former colleague Justice Rehnquist to join you there?
Well, we were copying Thurgood Marshall's. Thurgood Marshall didn't bring Brown v. Board to the court as the first case. He built stairs to get there, and that's what we tried to do. Tried to bring cases that it was so clear that the law was in violation of the equal protection principle. You mentioned that some of the plaintiffs were men, and Stephen Weisenfeld is the perfect example of that. This was a man whose wife died in childbirth. She had always been the dominant earner in the family. And he decided when his son was born, and the doctor said, "You have a healthy baby boy, but your wife died of an embolism." Stephen Weisenfeld vowed that he would work only part-time till the child was in school full-time. And he went to the Social Security office to collect what he thought were child and care benefits. He thought he could earn up to the earnings limit, and with the Social Security, he could be the caregiving parent. He was told, "Well, this is the law you're asking to get benefits under, but it says mother's benefits." So that was a perfect example. The court was unanimous again, although they divided three ways on the reasons. Some said, well, it's obviously discrimination against the woman as a wage earner. She pays the same Social Security taxes as men pay, but the law doesn't give her family the same protection. Some thought it was discrimination against the man as parent. And one, who was then Justice Rehnquist, later Chief Justice, said, "This is totally arbitrary from the point of view of the baby. Why should the baby have the opportunity for the care of a sole surviving parent when the parent is female, but not when the parent is male?" So it's confronting the justices with real-life situations so that they could understand that what they once thought was a system operating benignly in women's favor, in fact, disadvantaged them. Even in Stephen Weisenfeld's case, why was the law that way? Because women were thought to be the caregivers of the child. And when the woman is a wage earner, well, she's considered a pin money wage earner. Her principal job is at home. So it was breaking down the stereotypical view of men's roles and women's roles.
The Weisenfeld case is so important, and I think I detected in Derek a hidden rhyme. You said that the law is wise and felt, and I think you were referring to the case there. But when you talk about these cases, first of all, your command of the factual details is remarkable, but you also care. You so clearly care about what was actually going on. These are not abstractions to you. These are real human beings. Is this the best way not only to persuade justices, but to teach students about the Constitution, to tell them the stories behind the cases? And is that what we should do as we try to build out this Constitution, this nonpartisan Constitution?
Well, the rest of the story is that the baby, Jason Weisenfeld, went to Columbia Law School, and then he changed to investment banking. He is now himself the father of 3 children. And on May 24th, I will perform a wedding ceremony for his father, who finally, after all these years, has a partner he wants to share his life with.
What a denouement. You performed another significant wedding recently, that of a friend who's head of the Kennedy Center. You were the first justice to perform a same-sex marriage ceremony.
Yes, Michael Kaiser. It was a beautiful wedding. And his husband's name is John Roberts. I don't know if the chief is aware of that.
How did Chief Justice Rehnquist came around in the gender cases? How did you persuade him, or how was he persuaded?
I think as long as one lives, one learns. And the best example of that is his decision for the court in the case upholding the Family and Medical Leave Act. The chief had 2 daughters. He had 2 granddaughters, maybe more than granddaughters, but two from his oldest child. And I think he was devoted to the girls. And when his daughter Janet divorced, I think he felt that her girls needed a male presence in their lives. And that nobody saw this, nobody who came to court and saw that the chief would ever appreciate how devoted he was to those two girls and how much they loved him.
Now, if I were channeling the Justice Scalia character in the opera, I would say this is completely inappropriate. The law is supposed to be faithful to the original understanding. It shouldn't evolve. It shouldn't change. Why should the Chief Justice take account his daughter's views? Is that an appropriate thing for a justice to do?
Well, they are representative of the change in society, the change that parents now have, their aspirations for their daughters, or their support of their daughters' aspirations.
This is such a hard question to teach, and everyone wants to know the answer. How does the court take into account changes in society?
Well, in this case, in the Family Medical Leave Act, it was easy because it was a law passed by Congress. And Congress's authority was challenged as outside the domain of the federal government. So the chief was explaining why this law was national business, was a matter that the national government had the authority to deal with.
But there are cases that are harder. You courageously and presciently, but controversially, said at the time that Roe versus Wade was too broad, that they should have decided the narrower question in the case, but the court shouldn't leap ahead too far from society.
Well, it was a surprising decision in this way. You know, it's interesting. Roe v. Wade was not controversial when it was decided. It was a 7-2 decision. My criticism of it was that it moved too far, too fast. It was the first right to choose abortion case that the court had. And a single decision of the court made every law in the country unconstitutional, even the most liberal laws providing access to abortion. So the court took care of it all. Instead of dealing with the case that was before it, Roe v. Wade, came from Texas. And the Texas law was abortion never, unless necessary to save the life of the woman. It didn't matter that her health might have been disastrously affected. It didn't matter that the pregnancy might have been the result of a brutal rape. So that law, which was the most extreme in the country, was a good first step for the court to take, but it could have put down its pen at that point. A great constitutional law scholar, Paul Freud, when he was asked about what did you think of this Roe v. Wade decision, and he said, it's like the grandmother who trots out her grandson to impress her company and asks him, do you know how to spell banana? And the child answers, yes, but I just don't know where to stop.
And if it had been narrower, you argued, I think correctly, there might have been less of a backlash.
Yes, it was a single target to hit at, the unelected Supreme Court that had written this decision. I know there are many people who think I'm altogether wrong about that, and we can't know what it would have been if the court had taken a baby step instead of a giant step.
How does the court decide when to take the giant step?
Well, that you have to ask, and then we can't ask him now. But Justice Blackmun wrote that opinion. It is interesting that it was 7-2. It was only then Justice Rehnquist and Justice White who dissented.
And is your argument, you've been called admiringly a judicial minimalist, you think the court should always take baby steps? So even when it's reflecting social change, it's basically nudging or catching up, but it's not really pushing too hard?
No, sometimes. For example, in the aftermath of Brown v. Board, when there was out and out refusal to follow the law of the land, it was not just the Supreme Court, much more so, it was the judges in the trenches, in the trial courts, in the courts of appeals, who insisted that the law of the land is no forced separation of the races in schools. And some of them, their lives were in jeopardy, but they enforced the decision.
This is the 60th anniversary of Brown v. Board. I think it's later this month. The decision today is hotly contested. Just last week, you had this very interesting Schuette decision where people were on both sides about exactly whether the Equal Protection Clause requires color blindness or color consciousness. What does Brown mean today, and is there actually agreement about the core meaning of Brown?
I thought that the culmination of the civil rights cases that led up to Brown came, what is it, how many years later, 13 years later, in 1967, in Loving against Virginia. It was a story of a couple that grew up in a rural area of Virginia where people got along with each other. Racial differences didn't disturb their neighborliness. And so Mildred and Richard Loving met and came to D.C. to get married because they couldn't get married in Virginia. Went back to Virginia. One night the sheriff comes to their home, blares his flashlight on them, and said, "Get out of bed and come with me to see the judge." And they pointed their marriage certificate, which they framed, and he said, "That doesn't count for anything here." So the judge said he would not sentence them to prison if they agreed to leave the state of Virginia and never come back together. Well, then the civil rights movement and Martin Luther King were very important in the country. And Mildred Loving, again, like Sally Reed, just an everyday person, thought that maybe there was hope that the system would work for her this time. And so they brought the case. It ended, again, with a unanimous decision in the Supreme Court in 1967. And that's when I think the Loving against Virginia decision is when apartheid in America ended, not with Brown.
Justice Ginsburg, I would like to go on all evening, but you have to prepare for oral argument, I know, and you're very good about doing your homework. You've taught me and America many inspiring things over the years, but one thing I think we've all heard from you tonight is just the importance of paying attention to real people's stories. And if you can talk about the particulars that lead up to broad constitutional principles, then you've really learned something about America. Thank you so much for your service to America, and thank you for joining the National Constitution Center.